We're taking you back to the Western Cape High Court, specifically outside of the High Court, where we have Oliver Dickson, who's been interacting with some of the political leaders who were there to hear that judgment. Good morning yet again, Oliver. Who do you have up next?
Well, I have before me now, Umfundo, the judgment. I've had an opportunity to read through the dissenting part of the judgment and parts of the concurring judgment. Just to give you a sense, there were three judges on that bench. It was Judge Francis, Judge Davis, and the acting Deputy Judge President of the Division of the Western Cape High Court, Judge Lagrange. Now, it is Judge Francis that descends away from Judge Davis and the acting Deputy Judge President, Judge Lagrange. In it, Judge Francis makes a number of fascinating considerations, and he gives a view into what he thinks the President's prospects of success are in the review application. In fact, he goes as far as saying, and I want to quote for you directly from what he says there, because I do think it's an important part of the consideration. You will excuse me as I'm scrolling through the different parts of the judgment here. Judge Francis says, the President's prospects in the review must be weighed so that substance of what he attacks needs to be understood. The motion carried out carries four charges. Charge 1 alleges serious violation, read with different sections of the Constitution. Charge 2 alleges serious violation of Section 34(1) of the Prevention of Combating of Corrupt Activities Act, PRECA, and a failure to report the theft properly to a proper authority. And just charges 3 and charges 4 allege serious misconduct under Section 96(2)(b) of the Constitution in exposing himself to a conflict of interest in directing General Rueda to investigate the theft. Now, Judge Francis says that the President's prospects of success in the review application itself are quite slim and low, therefore that it must then be important for the impeachment committee to go ahead with its work. It's important to note that Judge Francis in this instance is the minority on the bench in this instance, so it is not the dissenting judgment that passes through. What did come out in the majority judgment penned by Judge Davis and concurred by the acting Deputy Judge President of the court, Judge Lagrange, is they held that at the interim stage, courts should not make a definitive ruling on contested legal questions. And the contested legal question in this instance is the legal question of the review itself. He says that the only ask is whether or not President Cyril Ramaphosa had a serious question to be tried, which he did. And it found that this is the very important part on reputational harm, the part where the President said he might be embarrassed, or at least the senior counsel Wim Trengrove made to this argument that the President might be embarrassed during these proceedings. This is what the court had to say on that. Judge Davis penned here that the reputational harm from a public impeachment hearing is genuinely irreparable, that the genie would have been let out the bottle, so to speak, once those proceedings starts. The horse would have bolted. And then that means that the court was convinced that the President would be prejudiced if a report which might potentially be an unlawful report becomes the basis of these public hearings. And these public hearings might well be public hearings where the President is subjected to false claims and disparaging claims, which he would have no recourse for. So I just thought I'd take you through some of those elements from the judgment, which, of course, was the curiosity of us all. How did the court arrive to the decision that it did?
Exceptional work there on your part just to get your hands on that judgment, because it's quite important when we look now at Judge Davis indicating that for him at least, he's of the view that an interim order does not, at least in its judgment, does not seek to enter the realm of dealing with the contested legal aspect or the legal question here being challenged. But then when we go to look at Judge Francis going on to entertain the legal question, saying we don't see any prospects of success when we look at that review application. So quite interesting that these two were starkly opposed to each other, whether one opted to entertain what would be the prospects when they now have that full-on Section 89 report review. And then with Lagrange, now we find that that one confined himself to the reputational harm, indicating that indeed that irreparable or irreparable harm would most certainly be suffered by the president. So must say quite important, and gives people some sort of understanding and rationale behind this decision that was split three ways, because all three of them have different reasons for arriving at whatever conclusion that they did.
Yeah, no, certainly. Look, I'll read further into the report, and there are some other legal considerations, such as the question of jurisdiction, which of course was painstakingly argued in this instance. One of the arguments that was raised was that the court does not have jurisdiction in this matter. In fact, that's the only question where all three of the judges, found consensus on, that the court does in fact have jurisdiction in this matter, given that the Constitutional Court was open to the idea of the Section 89 panel report being a reviewable report.